All right, the time is now 10:01, and we will begin the April 4th, 2019 meeting of the District of Columbia Board of Ethics and Government Accountability. My name is Tamika Collier, chairperson. I am here with Norma Hutchinson and Darren Sobin. The three of us constitute the sitting board members of the board, and we therefore have a quorum. Turning to the adoption of the agenda, I will give you a few seconds to review and suggest any changes. Hearing none, all those in favor of adopting the agenda, please signify by saying aye. Aye. Any opposed? All right, we have adopted the agenda. Moving on to the approval, of the February 2019 meeting minutes. I will note one little technical change, a period after the end of forward in the first paragraph. Any questions or comments? Hearing none, all those in favor of approving the February 9th, 2019 meeting minutes, please signify by saying aye. February 9th, it says February 7th. Sorry, February 7th, thank you. 2019 meeting minutes, please signify by saying aye. Aye. Any opposed? All right, the board has approved the February 7th, 2019 meeting minutes. Turning to the March, get the date right, March 14th, 2019 meeting minutes. I also note under paragraph 2, actually paragraph 3, there's no comment about the board adopting the agenda. And I recall that we did adopt the agenda at the beginning of the meeting. So I ask that you amend the meeting minutes to reflect that the board did adopt the agenda. Any questions or comments? No. All those in favor of approving the amended March 14th, 2019 meeting minutes, please signify by saying aye. Aye. Any opposed? All right, we have adopted or approved the March meeting minutes. Next, we will turn to Director Allen. Good morning.
Good morning. Good morning, Chairperson Collier and members of the board. I am Nicole Allen, Director of the Office of Open Government, and I am pleased to present this monthly report on the activities of the OOG. The OOG has continued to fulfill its mission of ensuring that all persons receive full and complete information regarding the affairs of the district government and the actions of those who represent them. I'll begin by discussing Open Meetings Act and Freedom of Information Act advice issued by the office. The office issued an advisory opinion on March 29th, 2019 regarding the D.C. Public Charter School Board's Open Meeting Act compliance. The advisory opinion addressed whether the D.C. Public Charter School Board met in an improper closed executive session, improperly noticed to the public its October 31st, 2018 meeting, failed to timely report to the public the outcome of a vote taken in closure, and draft meeting agenda did not provide the public with proper notice of the closed executive session. The OOG's findings were as follows. We found one, that the D.C. Public Charter School Board violated D.C. Official Code Section 2-575 by noticing its October 31st, 2018 meeting as closed to the public. We also found that pursuant to district case law, the District Public Charter School Board is a quasi-judicial public body. The D.C. Public Charter School Board's October 31st, 2018 meeting in closure was lawful as a quasi-judicial public body meeting to deliberate upon a decision in an adjudication action or proceeding. We also found the OMA requires a public body to report on the record any official action taken during closure, but only when it's appropriate to do so. The OOG found that the D.C. Public Charter School Board did not vote during its October 31st closed executive session. and the D.C. Public Charter School Board's decision not to publicly report the outcome of its closed deliberations on the October 2018 through 2019 charter reviews and renewals was lawful. The OOG also found that the D.C. Public Charter School Board violated D.C. Official Code 2-5765 by failing to provide in its December 13th, 2017 public meeting notice the requisite D.C. Code citation to the reason for closure and a description of the matters to be discussed in its December 13th, 2017 closed session. How did it come to?
How did this come to us?
It was a complaint
It was a complaint from
from the member of the public.
a member of the public. Who is our ethics counselor over there?
We don't. Our ethics counselor.
Anyone remember? And did that individual have were they aware, involved in this when you guys were going through this?
I'm gonna have to.
The general counsel of D.C. Public Charter Schools and the chair.
Is the general counsel the same as the ethics counselor?
That I'm not aware of. This is Ms. Shelton.
Mm-hmm.
Well, because you know who it used to be, right? The general counsel to the council, and
right.
you know that. So I'm a little surprised this happened. I guess with her departure, there was a void there. Okay.
These also weren't recent allegations, right? This occurred in 2017?
In 2017 and 2018. In October 2018.
Yeah.
But we will be monitoring compliance, and they admitted partial mistakes, so we will report back. And
they're going to rectify it?
Yes, absolutely.
Yeah, good opinion.
Thank you.
I thought so too.
Informal OMA and FOIA advice. Since February's board meeting, the OOG has provided, since March's board meeting, the OOG has provided responses for formal and informal FOIA and Open Meetings Act advice and technical advice concerning the use of the OOG's website for OMA compliance. The responses are as follows. The OOG provided 8 FOIA and 4 OMA substantive responses to requests for informal advice. The OOG also provided 5 responses to OMA requests for technical assistance.
Where are we on scheduling another Bega road show? That seemed to go so well.
I would defer to OG for the schedule.
I don't think that there are any currently scheduled. I did hear of the AMCs, the OAG's legal seminar for AMCs on Saturday, March 16th, and let them know that the road show was going to be coming their way. But I don't think we have any scheduled.
No, we have the next one is scheduled for April 17th. I forgot which SMD, but April 17th is next.
Okay, good. I encourage you to keep that Ward 3.
Ward 3,
Yeah.
that's right.
Encourage you to keep that going.
We will be there. The next item is the Open Meeting Act and FOIA audits. As you know, the OOG is continuing its comprehensive FOIA and OMA audit, and it anticipates completing it before August 1st, 2019, and will report the results before the end of the fiscal year. The OOG is actively seeking the services of a summer intern, and the summer intern will assist with the completion of this project.
Have you found anyone yet? Because I just got an email this morning from somebody at UDC that says their folks are looking for summer opportunities.
We're going through the DCHR summer intern process, but if you could forward that person's name, I would appreciate it. We would consider them.
Sure.
Okay. The next item is training and outreach. On April 19th, 2019, the OOG and OGE conducted a combined OMA and ethics training for commissioners of the Corrections Information Council. The next item is rulemaking. OOG has submitted for publication the D.C. Register new and revised regulations to implement the recent changes in the law and which make clarifying amendments to the OOG's regulations at 3 DCMR Section 104000. The regulations will appear in the Friday, April 12, 2019 edition of the DC Register.
And these are the ones that we looked at last month and said go forward with?
Correct. Staffing, in addition to the summer intern, the OOG has selected a candidate to fill the vacant position of IT specialist, and we are working with DCHR to extend an informal offer and plan to have the selectee begin by the end of the month. And the next item is legislation. On March 19th, 2019, Council members Charles Allen, Brianne Nadeau, Alyssa Silverman, Mary Che, and Anita Bonds introduced Bill 23-0199, the Public School Transparency Amendment Act of 2019. The bill was referred to the Committee on Education and the Committee of the Whole with comments from the Committee on the Judiciary and Public Safety. The bill proposes that public charter school authorities publish information regarding contracts over $25,000, require public charter schools, including its Board of Trustees, to comply with FOIA and the OMA, require the Public Charter School Board to deliver a report to the D.C. Council regarding the number of FOIA requests and the cost of FOIA requests, and require the OOG to provide biannual training to public charter school employees and the Board of Trustees on FOIA and the OMA. As Director of Open Government, I fully support the aspects of this legislation that subject public charter schools to FOIA and the OMA and require the affirmative release of information to the public. I see this as a step forward in increasing accountability and transparency in public education. My only concern with the bill is the increased burden on the OOG staff to provide training. Given our small staff, if the bill passes, it bolsters the argument that the OOG needs another attorney or other resources to facilitate increased training capabilities. The OOG will monitor the progress of this bill and inform the board as it moves forward.
And this will be something that you'll raise during the testimony for the budget oversight hearing?
Absolutely, yes.
Are you planning to testify in support of this bill when there's a hearing on it?
I'll consult with the board on that and let you know. I have no plans thus far.
So you haven't been invited to do so yet
No,
by any of the sponsors?
not yet. But I will keep you posted, and we will continue to communicate with offices on the bill.
Because it's Charles Allen, you might want to expect an invitation.
Yes.
Just be prepared.
Yes, absolutely. This concludes the OOG's Director's Report for April 4th, 2019.
Thank you.
Thank you.
Director Wolfenbarger, good morning.
Thank you, Madam Chair. Good morning. This is the report update on the status of the Office of Government Ethics Operations, recap of previous month's activities. These reported statistics do not reflect status changes that we anticipate will occur as a result of actions taken by the board during today's meeting. Open investigations by status. We have 21 open investigations. We have 2 investigations that are open at the show cause hearing stage. We have 1 that is open at the negotiation status stage for a total of 24 open investigations. Pending stayed investigations by status. We have 13 that are closed pending collection. We have 1 that is closed pending an appeal to the D.C. Court of Appeals. We have 3 that are closed pending external action, which in most instances involves the employee completing their required ethics training. We have 1 that is stayed pending a D.C. Superior Court case, 2 that are stayed pending OAG False Claims Act cases, 7 that are stayed pursuant to OIG investigations, and 5 that are stayed as U.S. District Court cases, for a total of 32 pending and stayed investigations. Regulatory matters, we have 24 that are closed pending collection, 1 that is open, 2 that are open on appeal to the director, and 1 that's open on a board appeal, for a grand total of 28. Comparing the statistics for this month to the past 2 months, We currently have 24 investigations that are open. That is a decrease of 5 from the previous month of 29, and a reduction of 7 from the 31 we had open in February of 2019. We have 15 investigations that are currently stayed and active. That is an increase of 11 from last month and an increase from 10 in February. 2 of those we just received and opened and immediately put it into stayed status because after consultation with our OIG counterparts, we realized they were going to take the lead. So it's not something that we had on our books for a while. It's something that we just created and then put into stayed.
Okay.
Publication and reporting obligations. Now that the second quarter of FY19 is complete, we are working on the next quarterly complaint report, QCR, for the first quarter of fiscal 19, and we'll publish it to our website later this month. After working with our CMTS vendor, the bulk of the QCR each quarter will be automatically generated directly from our CMTS case management system, requiring much less manual effort than in the past. We are also working to assemble our second quarter performance and workload measurements, which must be entered into QuickBase by April 19th. Trainings and outreach attended by staff. Investigator Corrales attended 3 training webinars, collecting advertiser ID evidence in criminal investigations, which is a webinar conducted by the National White Collar Crime Center, cognitive interviewing and courtroom testimony, which was also offered by the NW3C, and interviewing children in an investigative setting, More Than Meets the Eye, which is a webinar conducted by Eyesight. And Investigator Bradley also attended the NW3C's Collecting Advertiser ID Evidence webinar. Trainings conducted by staff. Since the date of the last meeting, we conducted or participated in 8 trainings, 1 more than the 7 we conducted last month. The 8 trainings consisted of 3 ethics trainings for public charter school board members, HBX, and Councilmember Todd's staff, 1 board and commission training for the Correctional Informational Council, 2 new employee orientations, and 2 training webinars on the new lobbyist e-filing system. We're conducting a live in-person training program on the new lobbyist system tomorrow morning at 11 a.m. in a conference room on the 11th floor here at 1 Judiciary Square, and we have 2 more training webinars on the new system scheduled for next week. On March 19, 2019, the OOG and OGE conducted a combined OMA and ethics training for commissioners of the Corrections Information Council. And lastly, I gave an ethics presentation on Saturday, March 16th as part of the Office of the Attorney General's annual ANC legal seminar.
Excellent. Just want to recognize Attorney Advisor Ford. I saw the positive feedback and hear that you have jumped into the training fray.
Advisory opinions and advice. Informal advice, approximately 53, which is lower than the 72 reported at the last meeting. This number does not include responses we have provided to questions regarding the new lobbyist e-filing system. Additionally, it should be noted that only 21 days have passed since the board's last meeting rather than a full month. Formal advice requests, we have no pending formal advice requests. Ethics legislation / comprehensive code of conduct. Chairman Allen has introduced this year's version of the CCC for the Council's consideration, and Councilmember Breon Nadeau had introduced another bill on March 19, 2019, entitled the Ethics Reform Amendment Act of 2019. As I mentioned during last month's meeting, one provision from Councilmember Nadeau's proposed bill that is particularly encouraging from OGE's standpoint is language that would authorize us to obtain search warrants for electronic evidence as referenced in our 2018 Best Practices Report. We look forward to working with Chairman Allen, Councilmember Nadeau, and their respective staffs to advance these legislative efforts in furtherance of our agency's mission.
So has there been any movement on the CCC? I mean, I know the new legislation was just introduced, but they introduced the CCC in like first day.
Yeah, I have not heard any progress on that front. But I will follow up with Councilmember Allen's office to try to get a status update.
At some point, it's going to be a record for a piece of legislation that's been pending but never gets acted on.
Absolutely.
I mean, I recognize we are trying to get through lobbyist registration and budget season, but we need to be proactive to make sure that this moves because it seems to have the support.
Absolutely. Yeah, when Brian and I met with the committee staff about 2 months ago, they specifically noted several instances in the 2018 Best Practices Report where we identified instances where we had chosen to close investigations involving ANCs because the allegations involved violations of the DPM, and they noted that that was a situation that really needed to be resolved. So I'm hoping that serves as a catalyst for some movement this period.
And the ANC road shows, dovetails, and all of that.
Absolutely.
It's a plan.
Rulemaking. In the Dropbox, you will find the rulemaking that has been several months in the making. It contains a number of conforming and technical changes to our rules, including the change from a 3 to 5 member board and the accompanying quorum change. It is focused on the criteria the board considers when it has before it waiver requests, whether for e-filing or FDS or lobbyist fines. It also includes criteria for employee designation appeals. There are 2 versions in the Dropbox, one a red line version so that you can discern the changes, and a clean version that would be published in the DCR. Upon request, the red line version will be provided to the public, if not published on our website. Currently, it includes only entire sections that are being amended. It is contemplated that when the final rule is published, it will contain our entire body of rules so they are more readily accessible to the public. Another thing to keep in mind is that the agency has the discretion to finalize all or only parts of the rule depending on the comments it receives, as well as its further consideration of the rules. We are asking that the board approve the proposed rulemaking, which was originally shared in part in February regarding our regulatory appeal process, subject to modification by the legal staff if needed to comply with the technical and compliance requirements applicable to the rulemaking process.
I had a question. Looks good, by the way. I went through it. And so, Brian, you worked on these?
I did.
So on page 8, can you flip to page 8?
Red line version, I hope.
Yep, red line.
5402.2.
5402.2. So I recall when the Ethics Act was being created that there was a debate about this and about whether or not they should include, because this kind of comes out of the statute, or at least the original statute. I don't know if it's still there or something.
It's still in the statute.
Okay, because it was their concern that they didn't want a board that would simply just start referring over to the U.S. Attorney's Office all the time.
Right.
So does the current statute conform to this?
This parrots what's in the statute.
It does?
This just strikes it from our rules.
So we're not going to have it,
in the statute.
but it remains in the statute. And why do we want to strike it from the rule?
What's the comment? That there may be violations that would require us to expeditiously refer something to OAG or the U.S. Attorney without even an investigation, if it's so clear on its face that it's a violation, a criminal law violation, and we shouldn't even be taking jurisdiction of it. So I think, but again, it's going to remain in the statute. Can't strike it from that. It's only a question of whether, as a matter of policy, we want to keep it in our rules.
I just wanted to know the history of it because.
That's it. That's the history.
Okay.
I mean, the truth is, we would and do refer matters to OAG or the U.S. Attorney, again, if we clearly we have a duty to report certain types of violations. It's not something that necessarily we discover in the course of our investigation either. It comes to us with the allegation of a clear violation of criminal law.
I'm just concerned about someone looking at the rules, which they're supposed to parrot the statute and then expand on them, right? On the provisions of the statute. And so if something is in the statute, it's usually included in the rules and then just clarified or expanded. But this would actually be taking something out of our rules that exists clearly in the statute.
I mean, that's a real, difference in approaches to rulemaking, whether or not you should parrot what's in the statute or expand upon what's in the statute. This just parrots what's in the statute, so we're still bound by it. And I mean, if we want to make sure that anyone who's following the rules as opposed to the statute knows that this requirement is there, we can leave it in. It's just a recommendation. I mean, I don't think there's an issue with leaving it in either.
I mean, I don't have a problem with deleting it from the regulations, but it raises a bigger question if we know that we are not following, the statute, or in fact violating the statute, that may be at a different time, but maybe we need to move to have council address that provision.
I didn't look at the CCC to see how we treated this.
I think the
adult.
CCC was supposed to address that
Yeah.
and change it, because this has been an ongoing issue for us.
I don't have a problem with deleting it now that I know the history behind it.
But it is still in the
Particularly if it is in the CCC. So if we're moving, we've recognized that there's a conflict in the statute, and we have introduced legislation to change it, then I don't see a problem with deleting
I don't
it
think it's
from the
going to be an issue
regulations.
for the people who are in this room, involved in this discussion now, because they are going to understand this is still in the statute. For people who come after us, who may not, well, I don't know how you administer,
Well, hopefully
law
the
without
CCC
knowing
will
what
be
the law
past this council period, and, all right, Darren,
All right, if you want to take it out, I never liked it anyway.
That's probably why it was recommended.
5405.1, advisory opinions. The striking of the board for who can issue advisory opinions. I recall there was an opinion issued prior to my tenure by the board. If I understand correctly, they believed that the issue was of such importance that they wanted to make a statement by having the opinion come from the board versus the director, so there would be no appeal. If there are instances like that, do we want to strike the board from this provision?
I don't know that we would. And again, this was done a while ago, some of these revisions. I don't recall why we recommended that this be stricken, and I don't recall what the statute actually requires. I can certainly look at that, and then the question is, if the statute, I'd be surprised if the statute said the board or director, but if it does, certainly we can restore it.
Follow what the statute says, but if there are occasions where we determine that the issue is of such importance, again, prior to my tenure, but I believe there was at least one opinion where that occurred.
Well, from what I hear you saying, we should just leave it, because it's the board or director. Most of the time, it's going to be the director, unless the board really steps in and says we want to do it.
And
So we'll leave that the way it was, restore it.
5702.2. Looking at the factors for determining a late waiver request, my only recommendation is that you include a catch-all, good cause, extenuating circumstances like you do for the other areas.
That was part of the thinking for changing shall to may in the lead-in, but it would be,
It would be consistent with how you've addressed the other sections have a catch-all provision.
Okay, so we'll add that. Something that's consistent with the other provisions.
Yep, I agree.
Me too.
That's all I got.
I don't have anything.
So are we looking at it again, or are we going to approve it with those amendments in mind?
Well, you're confirming whether this,
You certainly want to specify that you want to see the final rulemaking. That's not necessarily a given. If there are no changes between the proposed and the final, then there doesn't necessarily have to be another review for the final, unless you basically reserve the right to review the final.
No, but one thing I will say, that I was mentioning to you earlier is the red line version that we have currently has your unadjudicated comments. So when you say you will publish the red line version, yeah, and make sure your comments have been addressed. So is this something we need to vote on, or I can just sign okay. It's completely up to the two of you. Do you want to vote today, or do you want to wait for them to come back with the final that they will submit?
As long as Brian does it before he leaves. I don't have to look at it again.
All right. All those in favor of approving the rulemaking with the edits discussed and with the understanding that General Counsel Flowers will consult the statute with respect to 5405.1, all those in favor of approving the rulemaking, please signify by saying aye.
Aye.
Any opposed? No. The board has approved the rulemaking as stipulated.
Proposed.
Yeah.
Thank you. Budget. We received updated proposed budget figures from OFRM on March 20th, reflecting a net increase of $80,000 over the original draft we received on March 11th. Excuse me. However, I'm concerned that while our non-personnel services budget, or NPS budget, went up by $70,000 from fiscal 19, $50,000 of that appears to be a one-time enhancement to fund the replacement of our AV equipment. Moreover, they cut our line item for regular pay continuing full-time by $101,000 for fiscal 19, or by $101,000 from fiscal 19's amount, while budgeting $171,000, which was a new allocation for regular pay other. Because of the reclassification and position changes we enacted in fiscal 18, Bega's Schedule A budget for fiscal 20 should be more along the lines of $1.77 million, which coincidentally happens to be the total amount we were allotted for the two regular pay line items. Even if we filled the auditor, IT specialist, and compliance specialist positions at the bare minimum step 1 level for their respective grades, we would still need $1.747 million, a total of $1,747,895.01 to cover our salary expenses. Moreover, by shifting those personal services funds from regular pay continuing full-time to regular pay other, I worry that it theoretically could make it easier for them to attempt to remove that second line item in the future, thereby jeopardizing our ability to keep the current number of FTEs on our staff, let alone to fund the additional 2 FTEs we requested in our fiscal 20 budget enhancement requests. And I will share my concerns on those issues in my testimony.
Did you ask about the inclusion of the new line item?
We have a meeting with OFRM. I have a meeting with them tomorrow morning, and I believe Nicole is going to meet with them on Monday. And between now and then, I will reach out to the city administrator's office to try and find out more about what exactly was going on, the thought process there.
Yeah, I'll also be in the meeting on Friday. I just confirmed I want to come in.
Okay.
The other thing is, I'm not sure if it was at the last board meeting or in emails we've exchanged since, but the idea was to start lobbying.
Correct.
Have we made any push to schedule appointments with council members? Or?
My thought, and Nicole and I haven't talked about this, we were going to probably talk about it tomorrow, was that it might be more effective to schedule those meetings after the testimony, just with everything that I've got going on with the lobbyist system and trying to keep that rolling on the tracks. I think after we get the budget, our testimony behind us, the budget hearing, that would be the time to then start scheduling meetings with the individual council members.
Okay. Just know that it runs it moves pretty quickly after the hearing. So you may want to start scheduling now for a
Okay.
meeting immediately after the budget hearing.
Makes sense. Regarding our fiscal 19 budget, it currently looks to be in good shape as we have passed the halfway mark, and our local funds currently have an available balance of 57% of our appropriation, while our O-type funds currently have an available balance of 63% of our appropriation. Our staff members have begun actively looking for training programs they believe may be well suited for their individual needs and career goals. I have provided the board with a spreadsheet reflecting both the methodology I used in formulating our fiscal 19 training budget, as well as each staff member's individual training budget based on their respective operational roles. Lastly, our fiscal 20 budget hearing is scheduled for Wednesday, April 10th. Nikel and I have been collaborating to prepare for the hearing, including written testimony. We are also meeting with our OFRM partners tomorrow to discuss a few details and further prepare for the hearing.
Isn't there a submission due today?
Oh, it's in the form of, to the extent there's no testimony, and I believe it's about the contracts that we have had, the contracts that we anticipate having in fiscal 20, and Sandra and Awan have been working on getting that prepared.
Okay, so we'll meet that deadline?
It's my understanding, yes.
Okay. Can you circulate what you submit to the board?
Absolutely.
And you are both working on written testimony?
Correct.
Yes. Okay. I'm not sure that I'm offering testimony.
Oh, you're not going to testify?
I will be there to answer questions, but I am still undecided whether it is prudent to offer testimony.
Next item on the agenda is staffing. We interviewed 3 candidates for our vacant auditor position next week, and I anticipate extending an offer next week. We also interviewed several candidates identified by temporary staffing agencies to help manage our lobbyist and FDS programs, and we selected Caleb Smith to fill that role. Caleb recently completed a 2-year stint as a program analyst with the Environmental Protection Agency, where he created and maintained master production schedules related to the agency's budget submissions to the White House and Congress. He also led and coordinated meetings with the EPA's Office of Budget senior staff and regional offices regarding the production of the agency's budget submissions, and followed up with the regional offices to ensure action items and deliverables were completed on time. He also has experience developing process improvements and drafting standard operating procedures, and we are very happy to have him here at Bega. And Caleb, if you'd like to stand up and let the board meet you.
Mr. Smith, welcome.
Welcome.
Regarding Octo's pipeline process, although it did not function as smoothly as we anticipated, we eventually identified 3 candidates for the tech support specialists who we believe will be able to fill those roles successfully and should be onboarded by next Monday. Additionally, I'm planning to hold off on adding a temporary system developer for a month or so because I want to incorporate feedback from the lobbying working group into the next stage of development efforts for the lobbyist e-filing system, and I'll discuss that issue at greater length shortly. Lastly, I'm sad to report that next Friday, April 12th, will be the last day at Bega for our General Counsel, Brian Flowers. We were all saddened to hear that he had accepted another position with the district, and he leaves big shoes to fill. Personally, I will greatly miss his astute legal insight and prudent advice, but we all want to wish him the very best of luck in his new position, as I am sure his new agency will greatly benefit from his unrivaled knowledge of district government as well as his seasoned judgment.
As I hope we will, if you're going to be the head of the, is it public? Okay, so Brian is going to be joining my old agency, the Attorney General's office, and he will be taking on the role of deputy, which would have been my old boss if I was still there, a position that I applied for and never got. So congratulations to Brian. It's a wonderful position, both for the mayor's office, for the attorney general, and for the council, for the city overall, because it has the opinions that come out of the Attorney General's office bind everybody in the district government, except for a few places, like Bega, for instance, we have a carve-out. But other than that, it is the law of the district. It is the interpretations that come out of there that guide the district government in all of its law practices. So congratulations, Brian. Well earned. We will miss you. I enjoyed working with you very much, and I don't think it's over yet.
I also want to extend my congratulations and wish you let me know where you are.
Same. Thank you for your service to Bega and invaluable leadership. But I'm sure you will continue to support Bega in your new position.
Yes, I'll be available, as will the entire legal counsel.
Next item on the agenda is litigation, status of pending cases. Garen Price, CA number 16-AA-1230. This case was submitted on October 24th, 2018, and we are still awaiting the court's decision. Next matter is A. Blaine versus Bega, OEA matter number J-0030-19. This is an employment matter involving a separated employee. We have submitted our draft response to OAG, which they will file on our behalf before our April 12th deadline. Lobbyist financial disclosure matters. I am happy to report that the April quarterly activity report filing period for lobbyists has been going much smoother than the last one in January. Last Friday, we sent an email to LRR system users and key contacts reminding them of the recent statutory changes and letting them know that we are taking a flexible approach again this filing period and will refrain from taking enforcement action as long as registrants submit their activity reports for the first quarter of calendar year 2019 no later than April 30th, 2019, even though the established deadline is April 15th. The email also included links to our website where they can download an updated version of our frequently asked questions document, as well as a new instructional guide we have completed for the new e-filing system. Lastly, the email informed registrants that Bega and Octo will conduct 3 more webinars and 1 live in-person training program on the new e-filing system between April 3rd and April 12th, in addition to 1 webinar we conducted on March 27th, and provided links where lobbyists could pre-register to attend those trainings. The feedback I have received regarding the new instructions guide has been very positive, and the number of support tickets we have received from lobbyists requesting help with the e-filing system has dramatically dropped when compared to the volume of help requests we received back in January. I believe we had 1 on March 27th, 1 on April 1st, and 2 on April 3rd. So compared to the avalanche that we had in January, I am cautiously optimistic that the publication of the new instructions guide, coupled with the numerous training programs we have offered and are continuing to offer, may be helping us to turn the corner and move beyond the new system's rocky rollout in January.
Yeah, I've seen the feedback, and I acknowledge and appreciate all the work that you've done to remediate the issues.
Thank you. Some of the proposals I've received from lobbyists regarding potential changes to the new e-filing system actually involve proposed operational changes to the way we have historically administered the lobbyist program that I feel were thought-provoking and worthy of serious discussion and exploration. As I reported last month, Brian and I participated in a lobbying working group meeting at the Wilson Building with committee staff and 3 lobbyists. After learning more about the nuances of the lobbying program over the past few months, I have proposed to the committee that we make our lobbying working group a more structured and ongoing monthly calendar event as opposed to a meeting that is only convened when some crisis arises. I have asked for one of the committee staff members to participate in those meetings on a regular basis, as it would allow the working group to obtain direct feedback from the committee on a real-time basis regarding ideas under discussion, thereby allowing us to modify and refine those ideas more effectively. I will also keep the board informed of those discussions to ensure that any proposed operational changes meet with your approval before they are implemented. In the next 2 weeks, we plan.
1 second. I'm trying to figure out, other than this was formed as a result of a crisis.
Correct.
What could you possibly have to talk about on a ongoing monthly basis?
Well, I think in the short term, I could see it being monthly. Long term, probably not. But some of the proposals that they talked about for the e-filing system, really involve changes of the way Bega has historically required lobbyists to report. For instance, proposal was made that the amount of additional insight that we get into lobbyist activities by requiring the clients to also file an activity report is not warranted by the amount of effort that it takes the lobbyists and the clients to file 2 reports. And the way the system is structured specifically is based on that need for both sides to report. So if we were to make the determination that that is an accurate assessment, then the e-filing system would need to be restructured and probably could be restructured in a more simplified manner.
I just don't want that committee to turn into a lobbyist effort, particularly if members of Congress or congressional staff, council or council staff are participating in it. I think you are touching a line if you're starting to talk about their requirements, which, if I understand, part of that is a result of legislation Councilmember Allen wanted about more detailed lobbyist registration. So if the purpose of the group is to address technical issues, that's great, but keep in mind that you are talking about committee staff members and lobbyists getting together with you.
Understood. I'll definitely tread lightly. See here. No. In the next 2 weeks, we plan to notify all public financial disclosure statement filers of their filing requirement via email and hard copy. We have engaged a mail merge service to handle the hard copy notices, and Caleb is creating a master list of filers that we plan to submit to Octo on Monday so it can be uploaded to the e-filing system by the end of next week. After the master list is uploaded, we can send an email notification to all the public filers, and Octo can begin creating this year's user profiles in the system. We anticipate all FDS filers receiving notice and having access to the e-filing system by Monday, April 15th, 2019. We still have approximately 200 PFDS non-filers from last season. We are continuing to formulate a strategy for conducting enforcement and will bring that strategy back for discussion with the board in the coming months. One subject that I would like to discuss with the board is the scope of my authority as director to correct late payment penalties that may be erroneously generated by our e-filing system without needing to request the board's approval for such action. It is my view that in such instances where late payment penalties are erroneously generated by the e-filing system, it would be unduly burdensome to require affected registrants to formally request waivers of those penalties and bring them before the board for a decision.
Sorry, I got distracted for a second. This is the issue that you raised last meeting. If I recall, Board Member Sobin asked if you, Mr. Flowers, had weighed in on the decision and you were going to do some research. I also posited that I didn't think it related to the inherent applied authority, that if it was a technical error or a system error, then it didn't meet the definition of late. But either way, we weren't going to assess or keep a penalty that wasn't deserved. But have you made any headway on this issue?
No, but I would agree with your analysis. If it's an error, it's an error. Just inform the people it was an error, it's a mistake. Move on. I really don't understand it. If the system generates an erroneous notice.
Right. That's
This arose in context with a regulatory appeal that we'll discuss later, pretty shortly, from GMP, where the system erroneously imposed a late fee because they filed a registration report for 2018 in December of 2018, and the system just automatically assumed it was late because it was filed after January 15th without first examining the date that relationship arose. It arose in December, so it was filed in a timely manner. And when the lobbyist reached out and brought that issue to my attention, she specifically requested a waiver of those late fees. And so it was that experience that led me to engage the board in discussions about the appropriate way to resolve it. And so until I received guidance from the board regarding your approval for me to take care of this, because it's not truly a late fee that will require your involvement, I did go ahead and prepare a waiver request for your consideration in connection with that particular incident.
Okay. I mean, we can address it when we get to that specific incident, but in general, if it is a system error that causes the issuance of a late fee, then I don't think that is OGE issuing a late fee. I do believe that is something that the office can correct and does not need a formal intervention by the board. And you should not require the registrant to file a waiver request.
No, not at all. They just took it upon themselves. So I think it's a feature number one, we've got to get that issue corrected in the system so it doesn't happen again. And number two, if they just bring it to our attention, they don't have to actually request a waiver of the fees. They just have to request a correction of the error.
Okay.
Lobbyist filing waiver requests. Pursuant to DC Official Code, Section 1-1162.32, subsection C, the Ethics Board may waive the penalty imposed for untimely filing of a lobbyist activity report for, quote, good cause shown, unquote. First waiver request on the docket is 18-0031-R, MDDC Credit Union Association. Mr. Murray's stated reason for his firm's failure to timely file its activity report is that he was hired on July 2nd, 2018, and that he submitted his own information to Bega on July 9th, 2018. He states that he was not notified about the fact that the deadline for the July lobbyist activity report in 2018 had been missed, but upon discovering that fact, he immediately filed the activity report when he got back to his desk. The respondent's lobbyist activity report for that period was filed on July 23rd, same date that he filed his waiver request. The amount of the fine levied was $90. On December 27th, 2018, Mr. Murray responded to our follow-up questions, including the following explanation, quote, I do not have any evidence that my predecessor had filed. However, I also had no evidence or indication that my predecessor had not filed. I did not have documents or emails from my predecessor which indicated that he did not file, so I would need to. He oversaw all PAC-related matters, so no one else in the association would have known that this was not filed. I was simply working under the assumption that he had filed all of the necessary paperwork in a timely manner. We asked the board to deny this request for a waiver, as our subsequent research has shown that the Credit Union Association not only filed its July 2018 activity report in an untimely manner, but that it still has not filed its January 2018 activity report at all.
Any explanation as to why they haven't filed?
I have not received an explanation from Mr. Murray, although he did express, when I sent him notice of my recommendation that the waiver request be denied, he expressed appreciation for my consideration in looking into the issue and promised to bring the firm into compliance as quickly as possible.
Any other questions or comments? All those in favor of accepting the recommendation of OGE denying the waiver request for DC Credit Union Association in matter 18-0031, please signify by saying aye. 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 Any opposed? The waiver request has been denied. Thank you.
The second waiver request is the one that I spoke about earlier, 19-0011-R, Goldblatt Martin Posen LLP, in regards to its client DC09 LLC. This is a situation I raised during the board's last meeting where the e-filing system erroneously assessed a late fee against a registrant. It is my view that in such instances, the director should be authorized to correct those erroneously assessed late fees without requiring affected registrants to formally request waivers of those penalties and bring them before the board for a decision. However, until the director's authority in this context is clarified, which I believe it has been, I felt it was prudent to submit this particular waiver request for a board's determination, and we asked the board to grant this request for a waiver.
Please don't post these meeting minutes with deny on, okay.
I've made several corrections.
All those in favor in the matter of 19-001 Goldblatt Martin Posen and accepting the OGE recommendation to grant the waiver request, please signify by saying aye. Aye.
Aye.
Any opposed? Waiver request has been granted. Thank you.
The third waiver request is 19-0012-R, the American Heart Association. Stuart Burlow from the AHA has asked for a waiver of the $300 late filing penalty assessed against the AHA due to confusion over the new e-filing system. Mr. Burlow indicated that he thought he had submitted the firm's registration back in January when he entered all the information needed to do so, but may have either A, inadvertently failed to jump through all the hoops needed to submit the registration report, or B, failed to file the $50 registration fee. OGE does not oppose this request.
Any question or comments? All those in favor in the matter of 19-0012-R, American Heart Association, and accepting the OGE request the OGE recommendation to grant the waiver request, please signify by saying aye.
Aye.
Any opposed? The board grants the waiver request. Thank you.
The next item on the agenda is non-confidential investigations, case number 18-0006P, In re Jack Evans. This investigation into allegations that Councilmember Evans violated the council code of conduct is currently stayed. And that concludes my report.
All right, we will now move to an opportunity for public comment. Remind you to please keep your comments to 3 minutes. Hearing none, we will now move into executive session to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-57B, to consult with an attorney to obtain legal advice, and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance, evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, and to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13. All those in favor, please signify by saying aye. Aye. Any opposed?
Aye.
The time is now 10:59, and we are in executive session.